Successful expert witness testimony doesn't begin on the witness stand. It begins the moment you become aware you might be retained in a litigation case. There are 10 rules of expert witness file documentation that are critical to your success on the witness stand. File documentation may seem to be an administrative task, but it's almost as important as the intellectual development of your opinion. Let me begin with 2 foundational premises to understand about being an expert witness. First, you are in a litigation matter, and the other side disagrees with virtually everything your side says. They'll do whatever they can do to undermine or discredit your opinion. Understand that reality. Second, nothing that you do in your workup of a case, nothing, is privileged from disclosure to the other side. Those 2 foundational premises are why proper file documentation is critical. Good file documentation means knowing what to write down or document in your files and knowing how to write it. Let me briefly summarize the 10 rules. 1. You can't clean up your file the night before your deposition. You'll be asked if you removed anything from the file and what changed in the last few days, and you must truthfully answer the question. Nothing I say eliminates your obligation to testify truthfully and completely to your analysis. That is the ethical and legal obligation of an expert witness. Number 2, proper file documentation begins the moment you pick up the telephone to take a call about a possible new matter. You must realize that the notes of this conversation and every conversation you undertake in the case could be used as Exhibit 1 in the trial against your testimony. 3. Therefore, don't write down irrelevant comments that a lawyer or client might make to you, such as, "The other side are a bunch of liars," or "They simply don't understand the facts of the case." Lawyers and clients will frequently make inappropriate comments, and when they do, you should ignore those comments and remind those people that conversations with you are not privileged. Conversations should be limited to a discussion of relevant facts related to your specific analysis. 4. The characterization of file comments is also important. All file notes should be written with a tone of objectivity, showing that your approach to the substantive issue in the case is detached and unbiased. For example, if someone tells you an opinionated comment such as, "The windows were faulty and they leaked," or "The doctor didn't follow proper procedures," don't write that down in a conclusionary fashion. Write it down in an inquisitive fashion. This indicates your objectivity and your willingness to look at the fact to determine if you independently conclude the opinion that was told to you. If you write down conclusionary comments early in your analysis, those writings will be used against you to infer you didn't reach your final conclusion objectively, that a conclusion was suggested to you by a lawyer or client, and you simply followed that suggestion. Some other important points about file documentation. Number 5, don't retain preliminary drafts of your analysis. They'll be used against you. Adopt the practice of iterating over preliminary analyses. 6, don't discard or destroy relevant file notes. Learn how to take them properly. If you destroy notes of meetings and conversations, you will be asked, "Why did you destroy these notes?" Don't destroy them, just know how to take them properly. 7, do not write memos of preliminary plans for your analysis. By definition, these memoranda are preliminary. Once they're reduced to writing, they become permanent. If they exist, it's improper to remove them from your file. Memos of preliminary steps that were either not undertaken or unsuccessfully undertaken will be used against you, possibly as exhibits against you on cross-examination. Number 8, if you have a practice of having senior staff review a junior staff's work, don't consider those review notes as part of your file, and don't retain them. They are simply internal comments to other staff members to correct or enhance their work. Once the review notes have been used for their purpose, they should be discarded. 9, indexing every document in your file and using a system of cross-referencing is critical. As the expert, you need to review every page in your file, and you need to be able to quickly find the sources of information, and an internal cross-referencing system is very important in that regard. A properly and well-documented file is proof of a good analysis, and it is typically intimidating to opposing counsel. 10, advise your clients regularly that communications with you are not privileged and are subject to discovery. Your email should not have a legend at the bottom that says, "This communication is confidential and privileged," because it isn't. Your email legend should say that email communications with you are not privileged in cases where you are designated as the expert witness. In conclusion, the importance of competent file documentation of your litigation files is vital. Improper file documentation can completely undermine an otherwise competent expert witness opinion.
Brian Brinig is an adjunct professor at the University of San Diego School of Law and managing director of the forensic consulting group of CBIZ, a national financial services firm. The strategies and tactics presented in this video presentation are discussed in complete detail in his treatise, Mastering the Art of Expert Witness Testimony, which is available by scanning the QR code on the screen or on Amazon. Professor Brinig is available for continuing education presentations and speaking engagements to professional groups.